how buying and selling is all regulated in Ghana. Okay. I have also sent you the slides with regards to what we did under company law. So in addition to what you are reading in the act, please have a look at the slides also, and then some of the cases that were mentioned. So when you read them and you have any questions, you bring them to class so that we are able to together solve the questions. Huh? All right. So please, does anybody have any question? With regards to your readings, does anyone have a question, please? Hello? Okay. Can I be heard, class reps?
Yes, Doc.
Loud and clear. We can hear you loud and clear.
So it means that you understand what you have read. All right. That's okay. Please, you have to. I continue to advise, encourage you to keep reading. You have to keep reading. God willing, next week, as we have agreed, next week when we meet in person, we'll have a test. Okay, so and the test will be on company law. So you have to read it, especially the reading assignment. Okay. All right. Henrietta.
Oh, sir, that's me, Michael. Sorry. Let me change the name.
You're not Henrietta?
No, sir.
Okay. Okay, so go ahead and
I've changed it, and this is Michael Dab.
okay.
So my question has to do with the document you gave us to read. I saw the introduction to company law.
Okay.
In it, the definition for company, it says that a company is an artificial legal person created by law. So what I wanted to find out was, the last time we had the discussion on the company, we were saying that it's an entity that is actually set up with the aim of making profit. So in an exams question, if you ask us what a company is and we write it's an artificial legal person created by law, is it also correct?
Yes, that's a legal definition. Hello?
Yes, sir. I'm here, sir.
Yeah, so that's a legal definition of it. So
okay. Thank you, sir.
But the fact that it's created to make profit is the general understanding of what a company is. But if you want to go by law, then that is it.
Okay, thank you.
You're welcome. Yes, any other? Joseph?
Yes, sir. Sir, please, good afternoon.
Afternoon.
Sir, please, the case between Moko and Kuma, I read the facts and other applications, but sir, one thing that struck my mind is the guarantor, Mr. Samuel Kwe. Sir, please, does it mean Samuel Kwe as the guarantee for his food? I want to know his place. Does it mean he's standing to, just in case when they forfeit, he will pay Oh, so I just wanted to understand his main purpose in the contractual agreement.
What are you saying? I'm not getting you. Say it well, please.
Yes, sir. So, sir, when you read the case, the contractual agreement, there's a guarantor. There's a guarantor between seafood and then East Food Coast Fishing Limited, who is called Mr. Samuel Queen. And he's been featured as a guarantor for East Coast Company Limited, East Coast Fishing Limited. So I wanted to know his purpose. What is his purpose?
What is whose purpose? The guarantor.
The guarantor, yes. Queen.
What is his purpose in the case?
No, what is his purpose in the agreement, like the guarantor?
Yeah, but if you are signing an agreement, we've done contracts. If we are signing an agreement and you need somebody to stand surety for you, what is that? What is wrong with that, Anna?
Yes, sir, because during the case, he was not featured.
Yes, but why would he feature? Because you have to look at the case in totality, especially in regards to what we are doing. We are saying that a company has it has a separate legal personality.
Yes.
So yes, and that is the fulcrum or the main the crux of that particular case, Moko and Kuma. I gave you Solomon and Solomon, which is an internationally recognized case. And in Ghana, you have to read Moko and Kuma so that you understand how a company stands as a separate legal person or personality. Okay,
Yes,
having full capacity of be able to sue and also be sued in its name. So that's the main focus of the case, not the guarantor. The guarantor is a surety for whatever. If you are picking a loan, if you are going into a contract and you want people to stand sureties, that has nothing to do with the case. And that's a normal thing. That's a normal thing that you do. So you may be, when you are signing a contract, you may be required to do that for them to be so certain of specific performance, your ability to maybe perform and all those things. They can ask that you bring somebody in to stand as a guarantor for you. Just like if you are taking employment and they ask for a referee or a reference letter, a recommendation letter, those things are just not. It's a special arrangement that you always have, and it's not backed by any law.
Okay, sir. Okay. Yes, please. Thank you.
Yeah. All right.
Hello,
so
Doc.
I believe. Yes, Richard.
Hello, Doc. Okay.
Yes.
A question, please. Regarding the case of Moko and then Kuma, does a director's high position in a company make them personally responsible for the company's unpaid bills? I want a clarity on that.
That's a question I have to ask you because you have been asked to read the case. Do directors have liabilities in terms of the company's debt? That's a question I can ask you in an exam. So you have to tell us. If you read the case, you will know. Yes, Richmond.
Hello, Doc.
Or anybody to help him, please. Does the directors of a company stand liable for the company's debt?
No, sir.
No. Sir, no.
Yeah, so a company
they are separate entities from the company.
So yes, sir. Please,
as held by the Supreme Court.
Yes, Michael. Michael, you have an dissenting view?
Yes, sir. I think they do. According to what we read, it says that they are liable to the debts of the company based on the shares that they have in the company.
Explain. Based on the shares that they have in the company. So the company will use their shares and then also come to them for them to pay. Is that what you're saying?
Yes, sir. That is what I read in the document you shared. It explained that they are liable for debts according to how much shares that they have in the company. So my understanding is that assuming the company is in debt, and then the shareholders of the company, they are actually, since they own the company by shares, and then these shares can also be converted into money. It means that in as much as when the company makes profit, they share the profit based on their shares. It means that they can also be liable when there's debt. You know, they can also be liable and share the debt based on the number of shares that they also have in the company.
Hey, Michael, you have to read that thing well. Michael, you have to read that thing well. What is your understanding of an incorporated company? Or maybe a company limited by shares?
So I understand it. So I understand that when it comes to, I think when it comes to partnerships, the owners
we
of
are talking about company limited by shares.
Yes, sir. I'm bringing it to. I wanted to start from there. Okay, so a company limited by shares is, as it sounds, the company issues shares for the owners of the business. So the owners of the business, even though the company is an individual entity, the company is owned by these owners who have legal rights to the company based on the number of shares that they have within the organization.
Hello, you are done?
Yes, sir.
Okay, so maybe you guys are not. So you have to read the act. Read the act, read the company's act, section 7. Okay. It's like if you go to section 7, it talks about the types of companies. So we have the 4 different types. So when you talk about the company limited by shares, it's a company which limit the liabilities of its members to the amount unpaid, okay, on their respective shares. That is what it means. And some other things. But what it means is that now you are saying that they have to share the debt of the no, it doesn't happen that way. It is whatever you put into the business, into the company, it's no more seen as yours. Okay, you have a share in the company doesn't mean that it's yours. When a company incurs debts or in case it has liabilities on its head, it's the company itself that must be able to pay. Okay. That is what it is. It doesn't come to you, the individual. So directors, you are not affected.
Okay. Sir, please, this is what I was talking about. Maybe I didn't understand it well. The meaning and characteristics of a company. The number 2, limited liability. It says that members are only liable for the debts of the company to the extent of their unpaid shares or guarantees.
Yes.
Their personal assets are generally protected.
Yes. So listen.
Yes.
Let's say, for example, your share is 100. Let's say out of the 100, one is 1 cedi, so you owe 100 cedis, right? If one share is 100 cedis and you have 100 shares, that means that you, as a member or as a member of the company, you pay 100 cedis. Is that not so? Then, at any particular point in time, we check whether members have finished paying or they have paid all their shares. Because the 100 cedis, it could be that you have paid 50 and you are left with 50. Do you get it?
Yes, sir.
So the 50 is the unpaid shares. The unpaid shares is not yours. It belongs to the company. So if a company has a debt, if a company like Solomon and Solomon, when it went into insolvency, they couldn't pay their debt and all that, they will now come to you, the shareholders, the members of the company, and check the unpaid shares that are left. So the 50 that you still owe to pay, that is what it will be. We will come to you for. You will have to pay it.
Okay.
It's not about your personal money.
Okay. So,
That's what it
I
means by the
understand.
unpaid shares. So if you have paid all your shares and you have unpaid shares of 0, then nothing will happen to you.
Okay.
So that is why if you're a member of a company, you need to pay all your shares. You need to, if you have shares, you need to pay the full amount, or you pay for all your shares, then you don't have any problem. The only thing you receive is shareholders profit, which is what? Dividends will come to you every period. That is all.
Yes, sir. I get it now. Thank you.
So it doesn't extend to your personal assets or your personal resources, but it's only on the unpaid. Sometimes you may have a very large company, let's say MTN. MTN floated shares. MTN is now public. Some time ago, it became public. You are aware. Public is where the members are more than 50. So when a company becomes public, they float shares. So when they float shares, sometimes they are on the stock exchange. Okay, and they float shares. So when they float shares and then you pledge to buy, let's say, 1,000 shares, and the 1,000 shares is, let's say, 100,000 Ghana cedis. All right. You can either pay, depending on the arrangement, you can either pay full or decide to pay half of it. So whatever is left becomes what we call unpaid shares. Unpaid shares. So if something happens to the company and you have still not paid those shares, then you have to pay up. So anytime the company is about to wind up, the company is closing down, what they do is that they look at their members and the unpaid shares that members have. And every member must go and pay those shares. You must pay those shares before the liquidator will now go into their liquidation. Else, it becomes criminal. So that is all. Okay. Which one you asked the question? Are you okay now?
Yes, please. I am.
Yes. So yeah, the directors are not, even though they have been appointed, the directors of the company have been appointed to now be in charge of the management and administration of the company. They are not liable for the company's debt. No. If they have paid their shares, so be it. If once they have paid their shares, then you cannot hold anybody responsible. So you cannot see that I've seen that Richmond is a director of MTN, and MTN is owing this company, and Richmond is very rich in the country. He has airplanes, he has cars, and he has a lot of assets. So we can take him to court and then lay our hands, or take him to Yoroku and lay our hands on some of his personal properties. It doesn't happen like that. It doesn't happen like that. So the company is always separate. It's always separate from the members. All right. So I believe we can move on. And earlier I was saying that last week we started looking at how we have codified the law relating to the sale of goods, and then let's say the buying and selling of goods in the country, how we have codified that under the Sale of Goods Act 1962, Act 137. So we discussed some of them. We looked at the capacity. We looked at the contract of sale, the nature and formation of a contract of sale, how a contract of sale comes about. We've also looked at the capacity to buy and sell. Okay. So capacity to buy and sell. We had an extensive discussion. We looked at the fact that minus, okay, minus. So what we stated was that the contract that regulates, the law that regulates regular contracts in the country also regulates what the contract of sale. And so therefore, if you are talking about capacity to buy and sell, you have to first look at the contracting age, which we did. And so we said, then what happens to those who are below the contracting age, and then but they are engaged in buying and selling? So we look at the exceptions, and the exceptions are stated in the section 2. Section 2, I think 2 and 3, subsection 2 and 3 talks about those exceptions where they need the minors need what we call necessaries. So I can ask you in an exam to explain what a necessary is and give examples in all the laws. So you have to look at that. Then we looked at how a contract of sale is made, auction sales. Okay. We looked at the auction sales where it involves reserve price and where there are no reserve price. Then how goods are ascertained. We have specific and unascertained goods. If you remember, I explained to you that if you go to a shop and you are buying cartons of, let's say, milk, okay, cartons of maybe dairy products like milk, Milo, and those things, cowbell, those things. And then the one that you see in the shop, okay, the ones that are given to you can be provided to you. You can physically see and touch. They are the specific goods. And the unascertained goods, the explanation is in the act. But to be brief, we talked about goods that unascertained goods which are not identified. Those goods cannot identify them. So maybe they are agreed on and provided to you in the future. So you can request that the company that manufactures milk, Ideal Milk, should give you maybe 20 cartons next week. It is not available now, but they should bring you 20 cartons. So we looked at how unascertained goods should be, okay, in terms of the full obligation of the seller providing unascertained goods to be exact, or it should match exactly as what has been agreed on in terms of quality, in terms of the quantity, okay, in terms of, because sometimes maybe you may have seen a sample, and so you based on it to request for the product. And so when the product are given you, they need to make sure that it matches the exact sample that you saw. Okay, so let's continue on that and see what we can do so that we will bring this buying and selling matter to a close. Today,
I'm coming to Gata now. I'm raised the
please
Gata.
just mute your microphones when you join. Okay. All right. So okay. Okay, so we are looking at quantity and quality of goods. So do we have our reader in the house?
Please, she's traveling though, so she's online, but she will not be able to read.
Okay, then get us a reader. So who can read for us? Who can read for us? Juliet.
So,
Kindly read what's on the board, please. Yes, we are waiting on.
yes, please, I'm coming. There's a little food in my mouth. I'm coming. So, by description, in a contract for the sale of goods by description, whether or not the sale is by sample as well as by description, there is an implied condition that the goods shall correspond exactly with the description.
Okay. Okay,
So,
so no, so wait. So please, you've seen that there can be sale by description, sale by sample. Okay, so by description means that you go to the shop or you go to the seller and then you describe how the goods should be. Okay, so the law is saying that there's an implied condition that the goods shall correspond exactly with the description. You described it. So once you described it, then the goods that provided to you should match exactly with the description and nothing else. Okay. 12, section 12.
so by sample,
Mhm.
in a contract for the sale of goods by sample, whether or not the sale is by description as well as by sample, there is an implied condition that the goods shall correspond exactly with the sample.
Okay.
Yes. Okay. 13. Quality and fitness of the goods. 1. Section 1. Subject to this as and to any other enactment. There is no implied warranty or condition as to the quality or fitness for a particular purpose of goods supplied under a condition of sale, except if that there is an implied condition that the goods are free from defects which are not declared or known to the buyer before or at the time when the contract is made, but that condition is not an implied condition. I, where the buyer has examined the goods in respect of defects, which should have been revealed by the examination. I, in the case of a sale by sample, in respect of defects which could have been discovered by a reasonable examination of the sample. I, where the goods are not sold by the seller in the ordinary course of the seller's business, in respect of defects of which the seller was not and could not reasonably have been aware. B, that where the goods are of description which are supplied by the seller in the course of the seller's business and the buyer expressly or by implication make known the purpose for which the goods are required. There is an implied condition that the goods are reasonably fit for that purpose.
Okay.
Two, the condition implied by paragraph A of subsection 1 is not affected by provision to the contrary in agreement where the goods are of description which are supplied by the seller in the please go up.
Okay. Please, I hope you understand what it is reading. If there's not anything you don't understand, let me know and I will explain it. Yes, go ahead.
By the seller in the ordinary course of the seller's business. 3. The condition implied by paragraph B of subsection 1 is not affected by a provision to the contrary in the agreement unless the seller proves that before the contract, the seller proves that before the contract was made, the seller proves that before the contract was made, the provision was brought to the notice of the buyer and its effect made clear to the buyer.
Okay.
So 3.
No,
The
4,
condition
please.
implied by
No, no, 4.
4. An implied warranty or condition as to quality or fitness for a particular purpose may be annexed by the usage of trade. 5. An express warranty or condition does not negate a warranty or condition implied by this act unless inconsistent with this act. And then 6. This section implies to goods delivered in pursuance of the contract and extends to the boxes, tanks, bottles, or any other containers in which the goods are contained. And then 14, quality of goods.
No. It's okay. Please, do we understand what she read, please? Hello? Class, please, do we understand what she read?
No, please. No, please. Oh.
Yeah, but you people are not talking. You are just quiet and you're all doing your own things. Some of you are just so not the attention to, you are not attentive to this class. All right. So let me show you something. I'm trying to, let's make some notes with regards to section 14. What she read in section 14 is, sorry, section 13. Please, can you see the word? Is what we call,
Yes,
what
Yes,
we call
sir.
caveat,
Yes, sir, we can.
caveat emptor, or caveat. This is the principle. So please, you have to make notes. I'm trying to make the notes for you. Benditor. Have you heard of caveat emptor before?
no, sir.
Okay. So you realize that when what she read in section 13, or if you go back and read section 13, there are implied terms, okay, as to the quality and fitness of the goods. And this represents an important step in the abandonment of the common law. So common law principle. So the caveat emptor, sorry, it's a common law principle, okay, which section 13 seeks to now deviate from. The principle is also called let the buyer be aware. Sorry. Let the buyer beware. So if you hear caveat emptor, it means that let the buyer beware. So you are the buyer, okay? You are the buyer. Let me still go on with what you read. So you realize that the section 13 of the act it's been described as one of the most innovative thing that has happened with regards to the legislation. So act, sorry, with regards to the legislation act 137. One of the innovative things that has happened with regards to the act. When you start to read it, if we are to read over again, you realize that the beginning talks about this caveat emptor thing. Okay. It brings out the principle. Then the section goes on to, or it proceeds to create a raft of exceptions through what we call the broad implied terms that it talks about. Okay. And what happens is that a stipulation of maybe a number of these limited situations in which the implied terms will not apply also are given. So that is why she was reading A, I, and then you go to B, I, and so on and so forth. So it has given you stipulation of a number of the limited situations whereby these implied terms will not apply. The general principle that you find in the section 13, that's why I keep saying section 13 of the Act, is what is based on, or which is probably maybe based on the caveat emptor principle, is so overshadowed by the exceptions that the result is maybe it has become something close to a complete negation of the rule or the principle, caveat emptor principle. In terms of when you're talking about quality of goods. In 14, we talk about quantity of goods, but in 13, section 13, it talks about the quality of goods. So when you look at the quality of goods, then it's like the caveat emptor principle or the rule has been overshadowed. Okay, that's why I'm saying that it is negating that particular principle. Then the reason it has been reasoned that even though it appears that from that particular section 13, though it appears that we are starting with the principle, we have ended at the last part of it. Then the principle of the caveat venditor is what ends that principle. And the caveat venditor, it ends in that principle of a very novel and extreme form of it. Okay, I'm going to explain everything. But you realize that the responsibilities in terms of quality of goods. So we are looking at the quality of goods. When we talk about quality of goods, I hope you understand it. So the quality of the goods, okay, which has been supplied by the seller, whether the seller is a manufacturer or a wholesaler or a retailer. Okay, in that particular construct or in the section 13 is placed on the seller. So everything when it comes to the responsibility in terms of the quality of goods, everything is placed on the seller. But you realize that when we say caveat emptor, it means that let the buyer be aware. The buyer be aware. So when you are going to buy a particular product, okay, the seller of the product can what? Just make the product available, the goods available in the shop, whether it is a defective good or it is not, it is a very fine or good, a good that is not defective. So all the product can be there. Or what they are saying, the end saying, shop. Then you, the buyer, you have to go and make sure that whatever that you are buying is what and not a defective good. That is the caveat emptor principle. But if you look at the act, that common law principle that you, the buyer, must make sure that the product that you are buying is not what defective, is negated. It's negated. And it's very significant to note that in the case of the latent manufacturer defect, latent, when we say latent manufacturer defect, maybe when the product was being done at the manufacturer level, in the factories, the defect came about from a short of maybe resources. Okay, into I didn't know product Nankasa, it didn't come out as a quality product, and the product is in the shop. That one is a latent manufacturer defect. You can also have even expired goods. The goods is expired and is in the shop. Okay. So when you talk about this latent manufacturer defect, then the retailer of the goods will be in the breach. The person who is retailing the goods is the one who will be in the breach of what we call implied conditions, if he had no means of knowing of the defect. Say product na say, and I say, what that latent manufacturer defect, now the retailer is still retailing it in the shop. Then what happens is that he or she has breached the implied conditions, even if he had no knowledge of it, even if he did not know that the goods had that kind of defect. Because if you read the section, if you read the 13 very well, and I want you to read it very well, that's why I'm discussing it today. Liability for latent defect in goods sold is only avoided where the goods are not of the kind sold in the ordinary course of the seller's business. Okay. And the seller was not aware and could not reasonably have been aware of its existence. What it means is that if you are, let's say you are, what can I, you sell perfumes or you sell cosmetics. For you, you only deal in cosmetics. Maybe you have done that for about 20 years. Your shop, everything is that. Then somebody brought you laptops or phones, okay, phones for you to sell. It is not something that you do on a daily basis. It's not in your ordinary course of business, which means that it's not something that you do. So if those products, if any of them has a defect, which is a latent manufacturer defect, you will not know. And that's the only thing that will save you. That's the only thing that will save you. Please, you get it?
Yes, sir. Yes, sir.
I want to hear from many of you. We shouldn't be the same people who are always answering.
Yes, Doc. Yes, Doc.
Yes, Doc. Yes, Doc. It's okay.
Yeah, we are with you, sir.
So the seller is the one responsible for the quality. we don't use the caveat emptor principle that the buyer should beware. So you, the buyer, when you are going to buy something and Adena say never shop where, then the onus is on you, the buyer, to ensure that what you are buying is a quality product. No, the Section 13 negates that. That is a common law principle, which our act has deviated from that slightly, because what we read, it meant that it is the seller's responsibility to ensure that the product do not have those kind of defects. So if the product are expired, you take it from the shop outside. You take those products from the shop. You don't keep them in the shop, and you expect the buyer to now be aware that I have expired product. No, it doesn't work like that. And we are saying that product that have latent manufacturer defect, that one, it is not expired. It has the problem that it has is coming from the manufacturer. The person who produced the laptop failed, or he forgot to install Windows on it. That is a latent, or the person failed to install Bluetooth in the laptop. Every laptop must have a Bluetooth. Your own came, or you went to a shop, you bought a laptop, and it doesn't have that. That is a latent manufacturer defect. So that one, the seller, okay, that one, the seller, you can go back. That's why when you buy those products, you can go back and then either it is changed for you or it is fixed. The seller cannot say that there's nothing I can do about it. And we are saying that the only time that the onus or the responsibility will come on the buyer is when the seller does not engage in those products in the ordinary course of the business. So the person that has never sold a laptop before, he doesn't sell laptops. It was only one time that maybe somebody brought him 2 laptops for him to sell. So when he went to the shop, he told you that, oh, Miku, I don't sell laptops. I sell perfume. I'm into perfumes. And these laptops were given to me so I have no knowledge of the laptops. And so when you buy those laptops and they have those latent manufacturer defects, you cannot fault the seller. The seller can have a defense. So liability for latent defect in goods sold is only avoided where the goods are not of the kind sold in the ordinary course of the seller's business. Please write that down. I wanted to write all those things, but I'm just saying them so that you can capture them.
Doc, please, can you go over it again?
Hey, go over what? I'm not reading from anywhere. I'm saying that when we read the act, the Section 13, then first, I'm saying that the responsibility in terms of quality of goods supplied by a seller, whether as a manufacturer or as a wholesaler or as a retailer, in the construct of Section 13 is placed on the seller. So the responsibility of the quality of the product is placed on the seller. Okay, that's the first thing you need to know. Then it is also significant to note that in the case of latent, LATENT, latent manufacturing defects, a retailer of goods will be in breach of the implied condition, even if he had no means of knowing of the defects. So still, you are responsible for it. Okay, so that is the main thing, the main law. Then the Section 13 has provided some exceptions, and the exception is that. So you say that maybe according to Section 13, I think it's the B or so, but let's say according to Section 13, later we'll go, I'll show you the exact place. The liability for latent defects in goods sold is only avoided where the goods are not of the kind sold in the ordinary course of the seller's business. Sold in the ordinary course of the seller's business. Maybe you can add that, and the seller was not aware and could not reasonably have been aware. The seller was not aware and could not have reasonably be aware of its existence. Yes, he was not aware and could not reasonably have been aware because he doesn't deal in that kind of product or goods. And you don't sell phones. So when a phone you are going to sell, maybe in your shop, you have just one phone that you are selling, and that phone does not have a Bluetooth in it. The manufacturer forgot to add a Bluetooth in it. How will you know? So that can be your defense. But if you are a phone seller and those things, okay, there are latent manufacturing defects in the goods, and you still go ahead and sell to your what? To your buyers, your customers, they can take you on. So if somebody come back, you sold a phone to somebody or you sold a car to somebody and the person came back to you and said the car, they didn't install ABS or they didn't install Bluetooth in the phone, and you try to argue with them, they can take you to court and win in terms of breach in the contract of sale. Okay, so what the shop owner, what they do is quickly they will just change it for you, give you another one. But if you insist that you will not do that, then you'll be in trouble. So the liability is very, very strict. It's very, 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 very strict. Okay.
Hello, sir.
Yes.
Sir, so if I get you right, let's say
you have
this,
to get me right. You have to get me right.
Yes. So if this supermarket, let's say the China Mall, so when you are going to buy things, there are shops that before you enter, they will say goods sold are not returnable. And I buy the goods and go, let's say a phone or any home appliance that you are talking about, and realize that there's a default or there's a fault, which was not from the seller, but the manufacturer. So do I have a right to send it back? If I send it back and they fail to take it or they refuse, do I have the same right to sue them?
You bought the good and you said, well, there's what?
Let's say the laptop that you are talking about. The laptop, you bought a laptop and there's no Bluetooth.
Yeah.
But then before entering or before buying, their terms are always that, or also that goods sold are not returnable.
Yeah. So what do you think, Paul? What do you think from the law that you are learning? What do you think?
Yeah, that's what I'm saying. For your explanation, I get it right that yes, I have the right to sue them. So that's why I want clearance that if
yes, but what clearance again? We are doing the law, so it is the law. So that is it.
So do they also have that law that yes, because they've made it clear that goods sold are not returnable. I've seen it.
Do you think that policy of goods sold are not returnable is powerful than the law? Hello?
Yes, sir.
Do you think the policy of goods sold not returnable?
So that's another context that I want to.
But what do you think? We have gone through this, and that's why you're doing business law. And I told you we started from the Article 11, sources of law. Did you see any policy there? I have explained this thing to you, Paul, in the whole class. So you need to get it. At this point, you need to get it that if it is not law, the law plays higher than even the laws. They are hierarchy. In Article 11, they are hierarchy, and I've explained everything to you. So what will you do? Paul, please answer the question. What will you do?
I will sue them so that if
you just
they
don't say you sue them. Don't say the law must be applied. It is the law that must be applied. The policy of goods sold are not returnable. It is their own company policy. It is not law. Okay. So now we are talking about the law here, And we are saying that the caveat emptor principle, it does not apply in Ghana. According to section 13, the buyer be aware is not non-applicable in Ghana. And in Ghana, it is the responsibility of the seller to make sure that he or she is not selling defective goods. So if the person is selling defective goods and writes that goods sold are not returnable, is it not a good case for you?
Yes, it is, sir.
So don't ask. It's a good case for you. I'm not saying don't be asking questions, but I'm saying that the law supersedes everything. Okay, so what we are learning under the law is what we are going to apply. And that's why in the beginning, I told you that there are so many things that are out there and they are doing them wrong. A lot of these businesses are doing things wrongly. They are doing things wrongly. But yeah, you know, we like farmer nyame, those kind of things. So nobody is taking anybody on, and people think that what they are doing is right. That's why you have to come to business law class. Then you know that sometimes you may be doing things and it's against the law. And once it's against the law, if you are not careful and the law caught up with you, you'll be in trouble. You pay a lot of compensation, which can even go to the extent of collapsing your business. So we just have to be careful. Please, when you go back, you can read the 13 very well and see how the responsibility, the onus lies on you, the seller.
Yeah.
The seller has
Hello.
yes.
Okay. In answering Paul's question,
Yeah.
I heard you say that it becomes a fine case when is it because of their so-called disclaimer that goods sold are not responsible. So there is a presumption that they might be aware that there could be a defect with the product in question, for which reason they are saying that goods sold are not returnable. Are you saying it's a good case because of on these grounds?
I'm saying that we will ensure that we enforce the law and not the policy.
Oh, okay. So the law is the law.
Yeah. We will ensure the law because
Thank you, Doc.
whether they are intentionally doing it or not, I mean, you cannot tell me that goods sold are not refundable or returnable when the good had a defect in it. Okay, so it has a defect. So once it has a defect, there's no way I can use. Okay, I bought the phone because I want to use Bluetooth, and I realized that the phone doesn't have Bluetooth in it. But the same phone, I mean, it's not like the manufacturer decided not to put Bluetooth in iPhone 17. No, iPhone 17, when you check the specs and everything, it has Bluetooth. But this one particular one that I bought from you, it doesn't have Bluetooth in it. And you are telling me that it's not returnable? No. Do you understand? It's a defect. It's the manufacturer defect. So what you also, the seller, what you do is you also take it and then you also send it back to the manufacturer where you also got it from. So it goes back and back until the retailers and wholesalers all send it back to the manufacturer for the manufacturer to what? Install that particular thing in it. But if you say you cannot return it because you are in Ghana here or you are sitting somewhere, so you say you cannot return it, then the law will take its course. So we have to be very mindful.
Yeah,
Yes.
hello, Doc. Okay. Yes. Since we are learning, I want to ask this. So, granted, what you're saying.
I can hear you. Hello?
You know, sometimes you go and buy some things. I mean, normally this amount. Yet you go and see another person selling, supposed same product at a far less amount. And then you buy it and you get home and realize this.
No, Michael. Michael.
Hello, Doc.
What we are talking about is quality. We are not talking about the price.
Okay.
Remember, under the provision under the price is different.
Different. Okay. All right.
Yeah. Even the provision under quantity is even different. Where we are, the section 13 talks about quality only. Quality.
Granted.
So we are talking about quality. Then you also realize that if you go to Adidas shop that is labeled Adidas, you can get quality Adidas shirt or jerseys, which will go for, let's say, 5,000 cedis. You didn't go to Adidas shop to buy those things. You still want Adidas. So you went to Tudu in Accra and you got that place. When you go there and you buy Adidas shirts of 10 Ghana or 50 Ghana cedis, remember that the quality wise is not the same. So you cannot go back and say that I wanted the one in the shop, the Adidas shop, the original one. So you have given me a defective. No, you get it. So that one does not play here. That one does not play here.
Well understood, Doc.
You're looking for a certain brand. They have Nike. So you didn't, instead of going to Nike shop to buy Nike product, you didn't go there. You went to Cantamanto or maybe somewhere, and then you got what? NIBK.
Nick.
Yes, NIBK. Yes, then the Nike, the tick, your tick is, the tick is starting from this way. It has turned like that. Then you go to the court and say that I wanted Nike and I've gotten this, and they will ask you how much did you pay for it. Then you say, oh, I pay 50. They say, now Nike 20. You should rather be imprisoned. So you see that one. So that one does not. It doesn't come in here at all. You know that going to Tudu to buy a good or a product there, you will not get. You will get Togo quality. You will not get the original quality. You should be aware of this one. But what we are saying is, we are talking about where everything is supposed to be on the on equal level. So all of that things being equal, you are in a laptop shop. They sell laptops, and they have HP laptops, and then maybe MacBook laptops. Then you decided to pick HP, but you know that the specs in HP, it should have that. You should have that. Maybe you should have a keyboard on it, but because it's in a box, they didn't open it for you to see that there was no key parts in the laptop. You took it home, then you realize that it doesn't have key parts in it. This is a latent defect of the manufacturer. It is the manufacturer who has made the mistake, but they have sealed the box and brought it all the way from either China or USA. And it has gone through, let's say, a different retailer's hands. And the person sitting on circle and selling it didn't even know that it had this kind of defect. When you take it back, whether the company has a policy of goods sold are not refundable or returnable or whatever, they should be able to change it for you. They should be able to do something about it. But there are litigants in this. Somebody can be a litigant. The person who is a litigant will not even bring it back to the shop. He will just take you to court and say that you have breached the implied provisions, and so pay me this thing. But in Africa here, you see a lot of people, they will still waste time, take a car. Maybe they bought the laptop and took it all the way to, let's say, in Sawam. They will take a car back to you, you see, from in Sawam, and return it and come to you and say that I bought this, so can you do something about it? And the person will change it. So that is something that we do on a humanitarian grounds. But other than that, this is the law that says that it is the seller's responsibility. So the seller is liable for it. Okay. Please, if we are okay, let's go to 15, section 15. So that will be the last. So quantity of goods is in 14. Read it, you will understand. But there's something that I want us to look at. Delivery of goods. Delivery of goods. I think last week I mentioned it, but let's read it. So please, Juliet, are you there? Hello?
Yes, sir.
Today we have been disappointed by our reader, so kindly read the 15 for us. It's very short.
Delivery concurrent with payment. 1. Unless otherwise agreed, the seller shall be ready and willing to deliver the goods in exchange for the price. 2. Tender of delivery may be treated as ineffectual unless made at a reasonable hour. 16. Time of delivery. 1. Where a time is not fixed for the delivery of the goods shall be delivered within a reasonable time.
Within a reasonable time. Thank you very much. So the 16, that is all that we will do. We will read. So delivery of goods. 15 says that delivery is concurrent with payment. What it means is that the law under section 15 contemplates delivery of a physical good. So it's talking about physical good delivery. Okay, so when, I mean, these days, a lot of you are engaging those businesses where you'll be required to deliver the goods at their place of abode. It is worth noting that the legal meaning of delivery that we are talking about here is very different from the ordinary meaning. Okay, look at the section 15 very well. In law, when you talk about delivery, you are talking about the voluntary transfer of possession. Yeah, I showed you how the property in a good or in a particular good is transferred. Here, delivery is talking about the voluntary transfer of possession. Voluntary transfer of possession. We can quickly go to 81, section 81, and look at something there. Section 81. Please, are you with me, class?
Yes, sir.
Yes, Doc.
Please.
You have to be with me. We are digesting the law. So let's go to 81. 81 is on interpretations, okay? So let's see delivery. Look at delivery here. Have you seen it? Delivery means voluntary transfer of possession from one person to another. Nobody forces anybody to deliver. So deliver the product or the goods. It means voluntary transfer of possession. You have possession, so voluntary transfer of possession to another. This is the meaning of delivery in what? Section 81. Now we can go to 18. Section 18. We were on section 15, don't forget. But we are going to 18 to see something there. That's why the law, you read it together. So sometimes you have to read different sections to understand. Look at means of delivery. Okay. 18 is means of delivery. I'm reading it quickly. Unless otherwise agreed, the seller may deliver the goods to the buyer by A, transferring to the buyer the actual physical control of the goods. So you have the actual physical control of the goods. So that is the actual physical control of the good. Then 2, or B, transferring to the buyer the means of obtaining actual physical control. This one, you don't have actual physical control, but you have the means of obtaining actual physical control. What does that mean? Who can tell us? The means of obtaining actual physical control. Yes, Stephanie. Yes, anybody?
Yeah.
Oh, my.
So maybe probably you having documentation of the product.
Documentation. The person will give you maybe the product is logged in the harbor. Okay, come and pick your product. He has paid everything for you. So you give you the document that go there tomorrow morning and go and pick it. So the means of obtaining physical control is also given to you. So that is it. Then the C says transferring to the buyer the document of title to the goods. So have you seen? Now look at the 3. So you can just suppose the 3 and then understand what it means to now transfer or deliver goods. You can deliver to the buyer the actual physical possession. You can deliver to the buyer the means of obtaining the actual physical possession. And then you can also transfer to the buyer the document of title to the goods. So now, your way bill, we have something we call way bill or bill of lading or maybe invoice. Okay, so in your shop, somebody bought some goods and you have given the person the receipt that covers those goods, it means that you have transferred to the buyer the document of title. So when the person is holding that receipt, there's evidence that the person has the goods. Even though he has not taken physical possession, the goods may still be in your shop, but it doesn't belong to you anymore. Somebody has a receipt on it. So once the person has that kind of receipt, anytime he comes for the goods, sometimes it may be arranged that he comes and pick it maybe on a Wednesday morning or a Saturday morning or whatever. But if you don't have such an arrangement and he comes there and he cannot find the goods, you are held liable because the goods are not yours. He has the title. He has the title. All right. You go to 19. So when you're talking about delivery, 19, you talk about place of delivery. Place of delivery. And last week I told you, I think I've said it in passing, but look at 19. Unless a contrary intention is apparent, the place of delivery is the seller's place of business if the seller has one, and if not, the residence of the seller. So, to be told now the conifio the commander and how the shani baby, you have done yourself. I don't know whether you've done yourself good or bad, but it's up to you, because in the law, place of delivery is supposed to be at the seller's shop or the place of business, or if he doesn't have a place of business, it should be the residence of the seller. Okay, and to all those people who say that you buy and then we'll go and deliver for you, like if you buy cement and all those things, it is their own special arrangement. If something happens, it is against their policy, but the law says that you must pick the product from the seller's place of business. 2, in the contract of sale of specific goods, which to the knowledge of the parties, when the contract is made, are in some other place, then subject to contrary intention, the place is the place of delivery. So we know your contract say you are buying something, and I don't know that thing is at in my village. Okay, that thing that you are buying from me, you want to buy mangoes, and I tell you that, oh, I have mangoes, but the mangoes are in my village. So you pay for the mangoes and you expect me to go and bring it. No, it doesn't work like that. You have to what? The law says that. Then subject to contrary intention. So unless maybe we agree to me going to bring it, then the place is the place of delivery. The place where the mango is. That is where I will deliver to you. So this one is to protect those businesses that happens sometimes in the bush. You are going to buy maize and so many other things in the bush, and then you buy in the bush, you expect the seller to carry those goods from the bush and bring it to the town for you. It doesn't work like that. You have to, it will deliver to you at that place and you have to bring it. Please, any questions on these? Any questions? So if we go back to 15, now you understand it very well. So delivery, when the delivery is done, then the payment is given, or the payment can be given and the delivery is done. Okay, the seller has finished his job. Then you go to the buyer, Any questions? Hello? Hey. Class.
Hello.
That's why
Yes, sir, we are with you.
that's why I don't want to be doing
We are with
that's why
you,
I don't want
sir.
to be doing the talk. When I'm doing the talking, you people don't mind me. So I don't want to be
Oh, we
doing
are
that.
minding you, sir.
Okay. All right. So okay. Once you are not sleeping, then that's fine. All right. So please, we are done with this one. Duties of a buyer. Please read it. Now you know the seller, so you can read the buyer. The buyer too has some responsibilities. Okay. But we want to introduce the law of agency today. So let me close this one. If there are no questions, and then let me open this one. Yeah. If there are no questions, we want to go to any questions?
Please, I wanted to ask, so the online businesses, so their place of delivery, you see, most of them, they'll tell you it's an online shop. So if you want to,
so you have an arrangement. Online shop, maybe you may have an arrangement for it to be delivered to you at a specific place. So that one is fine.
okay.
Yes, any other question? Okay, work. So you know that when the law was made, 1962, we didn't have this technology. Yeah, we didn't have a lot of this technology. But please, do you understand the caveat emptor principle? Hello?
Yes, sir.
Yeah. Okay. So
Yes,
you can, if you are asked to explain it, you can explain it. It just let the buyer beware. So the buyer should be aware of it. It's a very common in law, so very common principle in law. Okay, please. If there are no questions, then we move on to, we just want to, we want to look at, hey, but nobody asked me this one. Seller, or let the seller beware. So, caveat venditor, that is what happens. That is what is in there. So, in our act, it's rather caveat venditor instead of the caveat emptor. All right. So, law of agency. So, when I prepare the notes, then I may add this one. So, we will first look at the the concept of agency or so what is the agency concept? That's the first thing that we'll then we will look at how to determine let's say determining the authority of an agent. This one we will not do much. So then we have types of authorities, but then maybe the last thing is the should we do obligations of the agent? Oh no, let's do the relationship between between the principal and the agent. All right. So this is what we will do. We will do the three things, and or maybe we look at how it is terminated. No, maybe you can. No, that one you can read it. So first, let's look at the concept. When we say agency or the concept of agent, what are we talking about? Agent. You sometimes hear that somebody is my agent. Okay, somebody is my agent. The person is my agent. So the law of agency. So we have a law of agency. The law of agency is embedded in. So the law of agency is an integral. Okay, integral area in. So the law of agency is found in what we call commercial law. Have we done something on commercial law? No, we haven't. Okay. Yeah, so it's found in commercial law. And if you look at the need, so what is the need for the law of agency? Or Elizabeth, please don't sleep. Oh, I can see you. You are sleeping. Elizabeth. She can't hear me too. Elizabeth, appear. Don't sleep. Okay. So the need for agency relationships is a response to the complexity of modern commercial life. You see, if you look at how the modern commercial life is, or commercial business is, then the law of agency is developed to closely relate to the changing needs for specialization and what we call division of labor. We have what we call division of labor. When we did management, remember division of labor. Okay, so division of labor call for what we call delegation. Okay, delegation of the various functions among specializations or specialties. So because of that, and then if you look at specialization, then there's a need for us to have the concept, or the need to have an agency relationship, because sometimes you, the principal, may not know, or you are not aware of certain things. Okay, you are somebody who you are interested in business, but your line of business is in a particular area. So the other areas, you may know people who are also very good in that. Then what you do is, because you want to commercialize all these things, then you get an agency or an agent who will be responsible for that. What they have, so the agent has what we call fiduciary relationship. My typing skills. Fiduciary relationship. Okay, you have a fiduciary relationship. To what does that do? So he has a fiduciary relationship to act, okay, to act on behalf of the person who is commanding him, or who is authorizing him, okay, on behalf of the person who has authorized him to do so. He has a fiduciary relationship, authorize him to do so. So when you ask somebody to do something for you, that person you have vested in that person a fiduciary relationship. Okay, so that person goes in there and acts on your behalf. Okay, if something happens, so we are learning the law, so you see what happened is that in the heart of this concept of agency is that particular contract, or the fiduciary relationship, which is sometimes written or oral. And it can be written down, or it can be an oral. Okay. Or sometimes not orally expressed, it can also be implied. And I'll show you what it means to be implied. And it can be implied through a conduct, or by operation of law. So you can have agency relationship that is through conduct, or by that. You can have an agency relationship that is implied by law. At the end, it's not like you told a person to be your agent, but if you look at it, because of law, he has become your agent. Okay. Sometimes also it can be that you have orally expressed it for the person to be your agent, or sometimes you have a contract with you have employed a person for the person to be your agent, or for you to have that kind of relationship. Or it can also be implied, but this time even though it's implied through conduct, the way you have acted. Nipano, oh yeah, it's like somebody being your betweener, that kind of thing that we used to have. So that is it. Please, any questions up to this point? Sorry. Any questions? Hello? Oh, no questions. Okay. So what we are saying is that the agency concept or the concept of agency enables, what we are saying is that it enables persons to act through representatives or representation in the discharge of their commercial. So that's why I said that. That's why I said that if you look at our commercial life, we are so busy. Everybody, you cannot be at two places at the same time. Okay, and people are so busy that these days you are thinking of making some money, so you are expected to be signing a contract in Dubai on a Monday morning, and they say Monday morning Ghana Gas wants to sign contract with you. So what will you do? Which one will you stop? Which one will you postpone? You can't do any of that. So what you do is that you create this concept of agency, or you engage a representative to go to the Dubai. You can quickly employ me, then you send me to the Dubai one to go and then do that kind of relationship for you. Okay? So that is what it means. So I go and sign the contract in your name, either in the name of the business or in your person. If you're a sole proprietor, then I'm signing in your name. If it's a incorporated partnership, I'm signing the name of the company. But you have given me that power to be able to do that. And that's why we are saying that it can either be written or it can be oral, it can be implied by law. And so please, you realize that flowing from what the discussion, the authority that is given to the authority of the agent is central. You see that it's central. The authority of the agent is central. In fact, if the agent does not have authority, then then what kind of, okay? So the authority of the agent is very, 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 very central. How does the agent derive his authority? Okay, that is why we go to the next one. We say determining the authority of the agent. I hope we understand it.
Yes,
Now,
sir.
if you want a
Yes,
case,
we do.
you know, when we are doing law, we always have to get a case. So let me give you a case for this one, because where I've gotten to, the next thing I'm going is determining the authority of agent. But here, let me give you a case. Japan Motors. You can look at Japan Motors Trading Company Limited and overseas Williams. I remember this one. I can give you the fact of this. Yes, Joseph.
Hello, sir.
Yes.
Sir, please, the fiduciary relationship.
Fiduciary relationship, yeah.
Yes, sir. Sir, can an agent hold the multiple agreements?
Yes. Yes, he can.
And to what extent?
He can. As to the extent, it depends on the agreement that you have with the person.
Okay.
Some people,
So, sir,
for some people, their work is to just be agents. There are some people that who are just engaged as agents. They don't do anything. All that they do is to do agency.
Those are, it means I can pick a foreign company, maybe Ties, maybe Dunlop. Can I also pick another, maybe in the US and then maybe Netherlands? Can I do that? Pick another Thai manufacturer and sell the two of them, represent the two of them. And legally, I'm fine. There's no contradictions.
I don't understand.
So what I mean is,
let's say Joseph, you are an agent, or you have agency company. An agent can either be a person, you, or you can create a business, a company that is solely into agency. Okay. So once somebody contracts you to do a certain work for him, or go and sign a contract or do something for him, the person has contracted you. To the extent of the contract, it is valid. So you do your work and you are paid. So you can, some of these agency companies, they can be engaging in a lot of agency with different principles. The only thing is that you have to be careful with conflict issues. You have to be careful with conflict issues. So you cannot, let's say the same agency, you are representing yourself, Joseph, and you are representing me, Afram, at the same time. When the two are going into a contract, then you, the same person, is representing that. Oh, you get it. That one will be a conflict.
Okay. Yes, sir. Yes, sir. Okay. Okay.
Yeah. So to the extent of the contract, you can be engaging in that. So the moment somebody is employed, it's like a law firm. If you're a law firm and somebody is coming to you are getting a client, then you have to survey that this particular client, what kind of litigation has or is he involved in, and who are the people that he's going to litigate against. Because maybe he's going to litigate against Fidelity Bank, and Fidelity Bank is already your client.
Right.
So if Fidelity Bank is your client and I come to you, you're a law firm, I come to you that, I want to go into litigation with Fidelity Bank because they owe me something, or they owe me money. I mean, you will not, do you understand? You
Yes,
think
sir, I do.
you quickly tell me that, Fidelity Bank is your client, so you cannot hold yourself in that kind of capacity.
Right.
That's it.
Yes, sir.
Thank you for the
Thank
question.
you. Thank you.
All right. So to explain this concept of agency, you can look at these cases: Japan Motors Trading Company Limited and Williams, or versus Williams, and then Boama versus Opon. I can give you that of the Japan Motors. What I remember is that in the case of Japan Motors Trading Company Limited and Williams, the court was faced with the following facts. One was that the plaintiff bought a motor vehicle. When the vehicle was broken down, the plaintiff contacted the defendant to provide spare parts from Japan for the vehicle. Then the defendant also contacted their suppliers, who gave a quote for the parts. Okay, assuming the defendant were ordering a large consignment, that is when they did they requested, because they thought that they were ordering a large consignment. When the supplier noticed that the spare parts were for one vehicle, they wanted to determine the agreement, but later they agreed to perform their side of it. Okay, I don't know if you understand it. Then the plaintiff at the time had already paid the defendant, who also paid the suppliers. So when the spare parts that the guy needed, Williams needed, were not forthcoming, the plaintiff now sued the defendant for monies paid, interest, and then damages. Do you get a story? Okay. Do you get a story?
Yes, Doc.
So he bought a motor vehicle.
Yes, we do.
He bought a motor vehicle and he wanted parts from the spare parts should come from Japan. So they also contacted them, but the suppliers thought that the price that they quoted, because they thought that Japan Motors was buying in a large consignment, not knowing that they only needed for one vehicle. And so they also delayed in supplying. So now the guy brought it to the court. Now in the court, his lordship, Amuasachi, I don't know whether some of you know him, he addressed the issue of agency, and then he stated something. So when it comes to the concept of agency, we are looking at what the Justice Amuasachi said. Okay. He said that there is another ground on which I think this appeal ought to be allowed. It is that as between the plaintiffs and the defendant, so I'm going to send you the case right away. I'm reading from the case. And the defendant, the agreement was one of agency and not of sale of goods. So you see, when it comes to agency and sale of goods, there are differences. Okay, so that is why we have done sale of goods and we are doing agency, law of agency, because Amuasachi make us aware that it's not the same. Okay, then he says that the distinction and its application have been explained in Benjamin's sale of goods, blah, blah, blah. When a supplier agrees to procure goods for another, excuse me. I want to share this one, what I'm reading, so that.
Sir, please, my hand is up.
Okay, go ahead. You have a question?
Yes, please. So, I want to ask if the law of agency is accepted in every institution.
Is what?
Like it's accepted in every institution.
It's
like
accepted.
Every company.
Law of
Yes.
agency is accepted. Yes. And it's a commercial, that's why I said it's integral in commercial business.
So say
You
like
understand?
this you like this. Can
GCT.
I hire someone to come and write my exam for me?
Hey, my dear.
Maybe
What are
I'm
you
not
saying?
around. So
What are you saying?
it
What
says
are you
so the
saying?
person can be my That's
But
why I'm
what are you
asking
saying?
if
You this one, what you are saying is it's not nice. I will not even allow
it
it.
says supposed.
Even if JCT will allow it, me, I will not allow it. For you, Nankasa. You have to sit there and write the exam yourself.
Yes,
You see,
sir.
you have entered into a contract already with GCTU that you abide by all rules and regulations. And one of the rules is that you sit for your examination. You, the student, sit for the examination, and no one else. Okay. So it's not now that you're already in the contract and that you'll be thinking that you want somebody to. No, you cannot do it. Okay, so please, this is the case. This is the case which I'll send to you. Japan Motors
Yes, sir.
Trading Company Limited versus Julie. You can see it, right?
Yes, sir.
So if you will go down, so it's where it's highlighted is where we are placing the emphasis on. So Amosachi, he said that there is another ground on which I think this appeal ought to be allowed. It is that as between the plaintiff and the defendant, the agreement was one of agency and not of sale of goods. The distinction and its implications have been explained in Benjamin's Sale of Goods, 2nd edition, paragraph so and so. And he goes on to say, when a supplier agrees to procure goods for another, he may do so as the latter's agent or as a principal party standing towards him in the relationship of a seller. A supplier who is a seller ordinarily contracts to supply the goods at an agreed price, whatever may be the cost to himself, and he undertakes absolutely to do so. A supplier who is an agent merely binds himself to use due diligence to fulfill the order. All this thing that he's saying, we have already said it all. We said it under sale of goods. The supplier that, functions of a supplier. We've said it. It is to be observed that the defendant never delivered to the plaintiff a pro forma invoice for their own, stating the price at which they will sell the goods to him, or the time within which they will deliver them, All they did was to give him a copy of the telex from the suppliers and ask him to pay the cost of the goods calculated from the unit prices given therein. The obligation which the defendant assumed towards the plaintiff was that of using their best endeavor to procure the goods for him on the most favorable terms available. The evidence showed that they were not responsible for the delay which might occur. I will allow the appeal. I see the evidence shows that they were not responsible for the delay which did occur. Okay, so you read the case, you understand it very well. I gave you the facts of the case. So this talks about the concept of agency. Okay. So some of these cases, when you read, they are interesting. When you read, you understand it. Okay. Let's boss on. Where were we? Okay. So the authority, the authority of the agent, determining the authority of the agent. We said that the central issue, so the central issue of an agency relationship is the authority. The authority it denotes. The authority it denotes. If you don't have authority, then you are even a fraud. Okay, you are a fraud. Because the label and designations that they use by the parties are only minor importance. What are the designations? Somebody is a principal, somebody is an agent. Those things are minor issues. The crux is you having authority. You having authority. So there are cases that will show, okay, and there are types of authorities that the principal can give, types of authority. So this one is authority. Number one, the first authority that can be is agency by agreement. That is what we were talking about. Agency by agreement. This is the most frequently used one. Agency by agreement. They have agreed. So it is the actual authority. Okay, agency by agreement is the actual authority that is given, where they have agreed. So the agency is created by the agreement between, so created by an agreement between the principal and the agent. Between the principal and the agent, they created an agreement. So you are employing the person. That is why we said that it can be a company or it can be an individual. You have employed a person to be your agent, to act in your stead in all matters or in commercial matters. That is agency by agreement. Agency by agreement. Okay. Then we have the second one. Please remember that here we said we are using this one. Remember, we said written, oral, implied. So look at written. Agency by agreement can be written, can be oral. Then we have agency by something we call estoppel in law. Estoppel. Estoppel in law. So in this case, in this case, what happens is that the concept of agency or agent by estoppel, agent by estoppel is or arise where a person acts with another. Okay, so on the belief that that person is authorized. Let me write it, then when I finish, I'll do the correction. Authorized to act. And he may even enter into transactions on behalf of another person. So in this case, what happened is that it arises where a person acts with another. Okay, it's acting with another on the belief that that particular person that is acting with is authorized to act and enter into a transaction on behalf of another person. So that person, a person who acts, induces another to do so, is liable for that transaction if the person acted on his behalf. So let's say Joseph, and then Joseph, your hand is up.
Yes, sir. Sir, please can you demystify the difference between the agency agreement and then the franchising under the law, or they are the same?
Franchising, what is that?
So, sir, somebody can maybe KFC take that, can be doing that here in Ghana. I want to delve into something.
But that is not agency. If that is franchise is different. We've spoken about that already. That's a form of business entity, external companies, how they come in. A form of business entity. So it's not under agency.
Okay.
Agency, you are letting somebody, you're letting somebody act on your behalf on a certain matters.
Okay. Okay.
On the agency relationship is not even in for a long term. Sometimes it's for short terms. Agency relationship, you enter it, you sign the contract, you are done, and papa, you get your money and then you go.
Right. Yes, sir.
Yes. So by estupel means that you are stopped from doing something. So it arises where a person acts with another on the belief that that person is authorized. So if Joseph, you are acting with Juliet, yeah, and you have the belief that Juliet has been authorized because she's classroom, maybe she has been authorized by me to enter into a transaction. And so you act with her to do that. That is what we mean. That is what we mean. So
yes, sir.
A person who acts induces another to do so, okay, is liable for that particular transaction as if the person acted on his behalf.
Hello, sir.
Yes, please.
And sir, the extopel, can it be maybe a pro bono cases while a plaintiff?
Some of you are lawyers
or
already.
Someone has
What is pro bono cases?
Say maybe maybe you a lawyer working coming to your aid for free, working for you for free. And I mean that in the case of maybe you are in the law court, you have an issue, you don't have a lawyer, but then the lawyer is opted maybe willingly to support you in your case. Maybe in that very cause, it may be that a lawyer can't, how the lawyer will let the case stand can't send you into trouble or take you out of trouble.
Yes, you see what we are doing is agency. Agency, let's say you, Gideon, Gideon, you know that every time I am signing a contract in Ghana, it is Joseph who signs the contract for me. You know that, right? You know that. So when you are acting with Joseph and Joseph tells you that he's acting on my behalf, would you disbelieve him?
No.
Gideon. Yes. So that's what we mean by estopel. Meanwhile, remember that as we are explaining it, it is not for every agreement because agency is not a perpetual thing. So maybe Joseph is acting for me in some capacities. Another time, or that particular contract or that particular transaction, I wanted Michael or somebody else to do it. But you have the belief, okay, you have the belief that it is Joseph who has been acting on my behalf. So you go ahead and do the transaction with the person. Do you get it?
Yes, sir.
Yes. So that's why we are saying that it's by estupel. Then, what will happen to me? If you sign that contract with Joseph, what will happen to me? I am the principal. Can I come to you and tell you that no, you are not supposed to have engaged Joseph, you are supposed to have engaged Michael? So who will be liable? That is what we are saying. Who will be liable? So in this case, that's why it's estupel is by estupel. In this case, I am estopped because I know that you know that it is Joseph who has been acting as my agent. But in this case that I wanted Michael or maybe Charity or somebody else to do it, I didn't tell you. Do you understand now? I didn't tell you. So who will be held liable? Joseph has already come and signed the contract. And why fault? I am stopped from saying otherwise. I'm stopped from saying that Michael is no more my agent. That is why when you engage somebody as your agent and you terminate or there's something that happens, you need to advertise it. That's why sometimes they advertise in the Daily Graphic and all those things for people to know, or you inform all your how do you call them? You inform all your business partners that this guy, this person is no more my agent. Else, he can go about and sign contract and you'll be stopped from claiming otherwise. Please do get it, Joseph.
Yes, sir. Yes, sir.
Yes,
And everyone
sir.
in the
Yeah.
and everyone in the class.
Yes, sir. Yes, sir.
Yes.
I
So
see.
if every time I am using Richmond as my agent, and every time I'm using Richmond can come and say that Afram told me to come and do this. Meanwhile, maybe that time I have not engaged him. So the moment I want to stop, I have to let you all know. So that is a stop. So I am stopped from claiming otherwise, that I did not wish to involve or engage this my agent. That's estupel. That's agent by estupel. Yes, please. Any more
Hello, Doc.
questions? Yes, please.
Hello, Doc. Okay, so I want to ask that, is it the same as the one whereby you see that people have issued disclaimers that so and so is no longer working with
Yes,
us, and so
yes.
anybody
It's your
who does
agent.
business with him, okay,
Yeah, you
all
do
right.
it at your own risk. So I am a bank. I am a bank, Fidelity Bank. I have some sale officers who go around and sign contract on behalf of Fidelity Bank. So they are always out there signing, and they have big clients. But now something happened in the bank, I have to lay them off. Once you lay them off, you have to involve or inform all your clients that Michael, Joseph, and co have been laid off from Fidelity Bank. If you don't do that, they can still go around. You know how human beings are. They can still go around and be signing the contract in your name. And they will go and sign contract with another big person who now will come to the bank and say that your people came to me, signed a contract, and I am looking for this, and it's nowhere to be. Then that is where you tell them, oh, these people, we've sacked them 2 years ago. And so we are not liable. No, it is agency by estupel. Because in the knowledge of the law, in the knowledge of the public, these people are your agents. So if they are no more your agent, publish it. So if you put it in the Daily Graphic and even they don't see it, you can use the Daily Graphic as your evidence in court. Michael, you get it?
Yes, Doc. Yeah, I get it.
You use the Daily Graphic as your evidence that, hey, when I sacked them, I even published it. This is it. So ignorance of it is not an excuse. So you did it at your own, because agency and the creative problems. And so the law is doing all of that to operate it. Okay. The next one is we have agency by operation of law. Please, I've seen that the time is, but let's finish this one. Then we can. Agency by operation of law. Let me quickly sum it up, then you get it. So this one, it operates by law in terms of the principle of what? Necessity. So you can say that maybe it has the principle of necessity to it. So okay, so let me I don't know, but let me end here so that we can. Let me end here. I know some of you are already tired. Let's end here. So we've done up to when we meet again, we'll continue, okay? Then we'll talk about the relationship between the principal and agent.
Hello, sir.
Yes, Thomas.
One last question. I wanted to add. So, in that case, what happens to the individuals that signed the contract if they were terminated but still were? Hello?
What will happen to that person? Nothing.
Yes, the individuals. Can the companies take them on? Yes, sir.
Yes.
Okay.
Yes. Company can this is it. So, Thomas, you know my whereabouts. You used to engage me to be your agent, to be signing contract, to be creating account. Let's say you're a bank, to be creating account and taking people's monies. Sometimes these people, this agent, they go about and take people's monies and come and deposit them. Okay. Now, I'm no more in your employees. I'm no more your employee. So if you don't publish it and I still go about and take somebody's money, the person that I took somebody's money and I did not bring the money to the bank, so I pocketed it, or maybe I did my own thing with it. Now the person came to the bank to withdraw and he realized that the money is not there. And then he said, but I gave the money to your agent and this is my receipts and all those things. You have to deal with that person and refund that person, give the person the money. Then when you are done, you look for me and charge me. You understand?
Yes, sir.
Yes. So the principle of the agency, the estoppel says that you are stopped from claiming that those guys are no more your people. Those agents are no more your agent. The moment you close an agency, a relationship with an agency, you need to let everyone know. You need to let everyone know. So that is why it is better you publish it. So the Daily Graphic and the dailies, if not Daily Graphic, maybe Ghanaian Times or some of these ones, then you publish it. Even if it is a very small advert, small one, like a passport size picture, you see, and put it in the Ghanaian Times. It is not. It doesn't matter whether people saw it or not. That one you don't care. Once you have published it, you have published it. In the law, it means that you have given the attention to the public. Do you understand?
Yes, sir.
So that is what we do, because people are bad. But let me also be very quick to caution all of us that if you are an agent, you need to also be mindful that you go and do some of these things. It doesn't mean that the law will also, you will be caught. Recently, some people have been caught. I think that you are aware that there's somebody who is going to about life imprisonment because of some money that he stole. He was working as an agent for a bank, and then he stole customers. He went around, collected customers' monies and did not deposit it. He wanted to run away with his girlfriend, and he was caught at the airport. And him, together with his girlfriend, they are all going into prison. So you also have to be mindful of some of these things. Anyways, please, I hope we have been able to learn some law today. As for your class there, you are master of law, so you have so many laws. So you have so many laws. And today we started with law of agency. Next week when we meet, we will conclude this one, and then we see where next to go. But please, next week we'll write a test, so prepare yourself for that. It will be on company law. Okay.
Hello, sir.
Yes.
So you still haven't given us the note, as to how we will be able to answer your questions and all that.
I have given that note.
IRAG.
I'm not giving you. I've given.
Yes.
I've given a note.
The Iraq.
Richmond, have I not given the Iraq?
No, please, oh.
Richmond. Ah,
Hey.
Doc.
let me send it to you right now. Together with the Japan Motors.
We haven't received that one.
Okay.
So, Doc, in the wake of this thing, maybe the next week exams, maybe you postpone it.
No. We will not do the next week exam. We will not do a problem question. You do it in the exams. In the main exams, we'll do problem question, and that will be a compulsory. That will be compulsory. There will be a compulsory question, which is a problem question. So everybody must learn. You all must learn how to answer a problem question in law. Problem question.
Okay.
A question will be simple. The question can be one line, but it's a problem question. You need to identify the problem in the question and then answer it.
Doc, can you give an example, please?
Example. Example is very simple. Japan Motor. Somebody bought a car. He wants the car broke down and is looking for spare parts. So he comes to you, requests you to provide a spare parts. Now you have taken the person's money. The spare parts has delayed. So now the name of the person is Joseph. So the person comes to you. You are a paralegal in a legal firm. So the person comes to the firm and your boss has asked you to write a legal advice. So what will be your legal advice? That's all. Simple question. But this question, you need to write plenty. The question is very simple, but you need to write plenty.
Doc, that's the problem.
Wow.
But this is a problem also. That's why it's a problem question. So you, the lawyer, or you are not a lawyer, you are a paralegal. You are
Sorry, I'm not.
Yeah, you are not a lawyer, you are a paralegal. You are working in a law firm as an assistant. So you need to advise with your knowledge of business law, advise your boss, who is a lawyer, on it. Simple question, but you need to write a lot. That's all. So you have to cite your case. Now I've given you 2 cases. What are the cases? First, okay, let's answer the question. So, Eunice, is Eunice there?
So I'm here.
So this particular problem, how do we answer? Area of law is what?
The question.
Area of law. Huh?
Please come again with the question.
Hey, what question? It's a problem that we read. So you are supposed
the
to
problem.
you are supposed to identify the law. Bismarck, identify the area of law.
There's a Company Act law.
There's no Company Act. What we have done today.
Sales
the
of
area
goods
of law. Maud, are you there?
I'm here.
What is the area of law?
Sir, please, I'm coming.
It's sir.
Yes. Emmanuel,
Sales
are
of-
there? I've not heard from
sales
you.
of
Emmanuel,
goods.
are you there?
Sir, please come again with the problem.
Richmond.
Hello, sir.
Richmond. Emmanuel, I'll come to you. Richmond, what's the area of law?
Sales of goods.
Hey, Richmond. What are you finding? Emmanuel, what's the area of law? Emmanuel, are they? What's the area of law?
Yes, so sorry, sir. I'm in a place right now. I can't talk that much.
Hello, sir.
Paulina did not come here. Yes, Bismarck. What's the area of law?
So agency law.
Paulina, what's the area of law? Hey.
Sir. Agency of
law.
agreement.
You want me to define area of law or the area of law in the question?
Wait. Listen to Paulina. Paulina, what's the area of law?
Sir, I say what is area of law or the area of law is
You are not getting it. The area of law, who can answer? Somebody was just answering. I thought it was you, Paulina.
Agency of agreement.
Yeah, you say the law of agency or the concept of agency. With this particular case that I explained to you, it is from what we are doing right now.
I said law of agency, or that's wrong.
And I didn't hear you. Sorry. So you have to say the law of agency or agency, the concept of agency. That's the area of law. So that one alone, you get your 5 marks. If you state it wrongly, you lose. So that is the area of law. Then you go to the next one, issues. IRAC. You go to I. I is issues. You raise issues. So I've told you that the issues, you start by saying whether or not. So let's go. Who can raise that issue? First issue. Whether or not. Every issue you raise is 5 marks. If we raise it correctly. Yes. Samuel Ochre. Okay.
The issues is what he can do, right?
The issue is the problem in the fact. This one is a fact that I've narrated to you. Let me say the fact again. William bought a vehicle from Japan Motors. When the vehicle broke down, William went back to Japan Motors and requested for spare parts to be shipped to him from Japan. He made payment for the spare parts. After 3 months, the spare parts have delayed. Okay, he went back to the Japan Motors, and Japan Motors have refused to give him any information. Unbeknownst to William, Japan Motors also engaged their suppliers in Japan, and their suppliers have refused to deliver. Now, they have informed William that they cannot deliver within the year 2026. William has come to you. You are sitting as a paralegal in a law firm. The name of the law firm is JCTU ICD law firm. And you are sitting the front desk as a paralegal. Your boss has asked you to write a legal advice for him on the matter. This is the question. But this question is loaded. This question is a problem question. So you need to use IRAC to answer it. And the IRAC, the first one is, what is the area? So you need to, now I read the question about 3 times. Area of law. That's why I said we have done so many law. We have done what? Constitutional law in this class. We have done constitutional law. Don't forget, this class, we have done legal methods. We have done contract law. That's what, anytime we are starting a new law, I tell you, we have done contract law. We have done tort. No law of negligence that we brought a guest lecturer to teach you. Okay, we've done company law. The company law, we did different sessions of it. We've done sale of goods. And today we've done law of agency, or the concept of agency. So you need to know. Question so you need to know which area are we talking about. Is it negligence? Is it about contract? If it's about even contract, you need to identify whether it is on offer or what, not offer. Okay, it can be a contract fact. So you have to read the fact very well. So the first thing you do, the first thing you do is to identify the area.
Can you have a double area or just a single?
No. For your class, there's no way I'll give you 2 areas. It will only be 1. And it is a areas you know, and it's a ufeliba. Because we failure, ufeli natural receipt, I told you. Ufeli natural receipt, the likelihood of a failure high. Because receipt will be amateur there. Yes.
You have to consider also with the fact that we are not law students.
That's why we are doing small. We are doing small bits. We are not doing in-depth law here. The contract, look at the contract, so
small pony.
But this thing, we just did it. This is the same case as the Japan Motors case. And I've read the same fact to you. This is the 3rd or 4th time. So I told you that before I gave you the case, I said that under the concept of agency, let me give you 1 case. I even gave you 2 cases. Instead of, I said 1 case, but later I remembered one, Kwame, and I gave you Kwame also. So it's the same Japan Motors case, which Justice Amwasechi from the Court of Appeal gave a ruling. Now I'm going to send you the ruling. Read it. So the first thing you do in answering the question is to identify your area of law. And the area of law is the concept of agency or the law of agency. Each one of them, either one of them you pass. You get your 5 marks. Then you come and raise your issues. So you write the issues to be raised are the issues. You shouldn't do more than 2. Each one will get you 5 marks. So raise the issues whether or not. Whether or not. So if you look at the fact, what do you think William can do? What do you think William, what is the problem? Which is related to the area of law, concept of agency, and the fact that has been given to you. What do you think? Yes, Michael, what do you think? Can you raise one area? Or Bismarck? Bismarck, your hand is up. Michael, prepare. Bismarck.
So is it an issue?
Yes, raise an issue. Let's go.
So whether the delay in supplying
whether
the spare
or not.
parts, okay, so whether or not the delay in supplying the spare parts amount to the breach of contract.
Fantastic. 5 marks. What you Obianko who Bismarck non how to raise it. Whether or not it amounts to breach. So we are talking about breach of the contract. Breach, whether it amounts to breach. Okay, so if it amounts to breach, then what is it? So the next one should be on agency. Because we remember that the Japan Motors is dealing with, he's acting as an agent for the original Japan Motors that is in Japan. Okay? So once they are not able to do it, then there will be a problem. So Michael, what will be the issue that you raise with regards to agency? The Michaels are not here. Any of Michael? Oh, okay. Paulina, do you get it now? Hello?
Please, I'm following.
But do you understand it now? I think the day we did the Iraq, you were not there.
Yeah. Please, I was here.
Okay. Who is raising the second issue? So the first issue, 5 marks, straight up. Second issue, Bismarck, let's go again.
So whether or not the what is the name? The buyer is entitled to remedies such as, let's say, damages or something.
Fantastic. The buyer is entitled to remedies, damages. That's all. Whether William is entitled to damages, that's all.
Okay, so say whether or not there should be a claim of damages.
So he's entitled to damages. That's it. So these are your 2 issues. You get 10 marks. So now you have gotten 15. Now let's go to the rules. The third part of the answering is rules. You need to state your rules. What are the rules that you state? The rules are the laws that you are going to use in analyzing the problem. So what are the rules that you state? Collins. Wait there, and then you're not wasting time. You people call for it. So I hope you guys understand. Collins, what are the rules or the laws that you use? Where is Charity? She's not here. Okay, Dinah. Who can raise a, because we did this one right now. Until the end, if you guys can do it, then they are here in the first day number guy. Eunice.
Okay, so as was held in the case of Buama versus Opong.
Yeah, so don't write that. Don't write as was held. Just the authority. Authority is Buama versus Opong alone. It's fine.
Okay.
Do you understand? Don't write as was held in the case of, you know how it was held in the case. So that one you wait on it. You are going to use that one in the application. But in the rules, you have to list all the authorities that you are going to use. In listing the authority, this is the trick. If there's a constitutional provision, you start with that one first. If there's a statutory provision, then you come to that one. Then case law. The same as you find it in Article 11 of the Constitution. That is how you write it. In the Emra laws, no, ebi was so simple. In the constitutional provision is always bigger and weightier than what statutory provision. And it also, a constitutional provision is always weightier than what judicial precedent. The one that Eunice just gave us, Buama versus Opong, is a judicial precedent. It's a case law. Case law. So you have to first check whether there's an act that supports it. Today, when we're doing law of agency, I did not give you any act. If you noticed, next week I'll give you an act, but I gave you case law. So once case law has been mentioned, that one is fine. What is the next case that can be used? Yes, Bismarck.
Please, I want to ask a question concerning the rule.
Yes.
Can you only state the law and then what it defines?
What it defines, you bring it to the analysis. Here, I want you to just state the law.
No, okay.
So what is the law? We have Bama versus Opon. Yes. Any other? Hey, this one can I call? Did they? Yes, Stephanie.
So, Japan Motors Trading Co. Limited versus Williams, sir.
Fantastic. Japan is the fact I gave you is from Japan Motors. And Timuko who the same factor. Why don't you think that Japan Motors is a case law that can be applied? They say you can get the same fact, but different names. I can say Toyota Company Limited. But once it's any Japan Motors case in the panel, you have to apply the principle in Japan Motors to it. Remember when we had our guest lecturer, he mentioned some cases. Donoghue versus Stevenson. The names in that case is Donoghue versus Stevenson, but you can get the same fact. If you remember the fact when the lady went with a friend to a bar and she wasn't not the one who bought the drink. It was a friend who bought the drink. And then when they were drinking and she took the first sip. Now she has drunk at half of it and she realized that there was a snail in the drink. Then out of that, she went to the hospital and got some disease, some reaction. And now she's suing. So if you get the same fact, and this time around we are using Casaprecumbites or we are using, a local drink here in Ghana, are you going to say that Donoghue Stevenson does not apply? It applies, pepe. So please, you have to get that straight. So the fact I gave you is from Japan Motors. So you bring Japan Motors Company Limited versus Williams, and then Boama versus Opon. Each case that you list, authority that you list, you get 2 marks. You get 2 marks. Then the next thing is what? Under IRAP is analysis. This is where you do the work, Ankasa. So if now you have, let's say you were able to list, let's say 5 rules. So you got 10. Then the issue 10, that is 20. Then the area of law 5, that is 25. Okay, that's 25. So you come to the analysis. There you can get 15 marks if you do it well. What are you going to do? This is where you apply the case law. I said, essay no ankasa. So anyway no. And this is where Eunice, I will expect you to be saying that in the case of Boama versus Opon, the Supreme Court held that this, or the court held that, or in the case of Japan Motors versus this one is that. Then you also explain what is the agency law. So the law of agency is about so and so. It does this and that. It can be this and that. All the notes I've given you today, you write everything there and the law of agency. Then you explain. Then how does the law of agency comes in here? You explain that the company working in Ghana is an agent company of the mother company in what? Japan. So when William went to the shop and bought the product, he had what? Engaged with the agency. And the agency do not have that authority. I'm going to show you the agency by operations and agency by ratification. Then you understand that are they, even though they are holding fiduciary relationship for the principal, but can they have influence over the principal? Agency, if you are an agent of somebody, can you have control or influence over your principal? So now the principal is saying that they cannot supply in 3 months. They even cannot supply within the year. What can the local agent do? The Japan Motors that is situated in Tema or Sprinters, what can they do? So you have to explain all this and with the law. Then you come back and say that in the case of this, according to section so and so, section this and that, the whole now throw at the Ankasa. Then the last thing is conclusion. You conclude. So, yes, Gideon.
You listing the rules, meaning the rules, those are the cases you expound on in the analysis, right?
Yes.
Okay, so can you list a case, but in the analysis you are not expounding, what you've listed in the rules.
Don't do that. It's not healthy.
Okay.
Don't do that. Like you are writing law of agency and you are listing offer cases. Then you are writing law of agency and you go and write NTAC versus entry and Manchester United, Manchester City Council versus Gibson. You are bringing those ones as less because of max. When you now,
no, sir, not that way. I mean, maybe you've listed Japan Motors versus Williams only, but in the analysis you are explaining Opon versus without explaining Japan Motors, even though they are all the cases are all related.
You have to explain it, because as you explain, you'll be getting marks for it. So you can say that what happened in Japan Motors is also supported by Boama versus Opon. Boame versus Opon.
Okay, even though you've not listed Boama and Opon in the rules.
Yes. If you've not listed and you bring it, you can still get marks for it.
Okay, sure. Thanks.
Then the last part of it, conclusion, you go back to the question. What did the question say you will do? The question said you were a paralegal. So advise your boss. The question did not say advise William. So you are not going to give advice to William. You and William, you don't have any relationship. You are to advise your boss. So you are going to write something there to inform your boss that this and that is what should happen. So there you write it from your own English and say that I will humbly and I respectfully suggest that we take this direction. We do this, we do that. You understand? If the question says that, so that side you have to read it very carefully. If the question says that advise your client or advise William, then you are going to say William should go to court or he should not go to court. You say that I will advise William to proceed to court since he has a higher chance of succeeding under the law of agency or the concept of agency. So you give an advice to William, the person who came to you. You give an advice in the conclusion. And that is all. When you are done,
hello, sir.
You get your 40 marks. Yes?
Sir, is there a way the conclusion may state as to whether advise him to go or not to go?
You always have to read the question. The last part of the question is what will help you to do the conclusion.
Okay.
The last part of the question will help you to do the conclusion. So in the exams,
please,
by answering, expect a compulsory question on IRA, problem question. Because I want to help you guys. I know that some of you from here, you venture into law and all those things. So I'm helping you. You come and thank me later. Yes, go ahead.
So, will we be answering it in an essay form, like paragraph by paragraph? Or
yes,
you have to list area
by the time you finish writing that question, you have gone like 8 pages. Probably now I know you can write. You have gone like, because the analysis, that's where the meat is. Is the analysis that's where the rest there, you are just stating them. And the analysis, that's where the meat is. So if you want 50 marks, you trust. So by the time you get to the analysis, if your area of law is correct, your issues are correct, your laws are correct, by the time you get to the analysis part, you have hit the motorway. And yeah, no answer will trust. Okay.
Hello,
So
sir.
we will not do problem question in the next week test. We will not do that one. That one, next week quiz is I don't know the format it took. Maybe it may even be but you see, law questions when it's true or false is very difficult. When it's filling to felon is better. But when it's objectives and true or false, they are difficult. If you are not careful, you get 0. So I'm looking at it. I don't know, but let's see what will happen. Maybe it can be true or false.
True or false?
So, and if it's true or false, it's very tough. If it's true or false, it's very, 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 very tough. So,
Sir, please, I have a question.
yes.
Okay, sir, please, at the point of the analysis, in writing, in making references to the cases, are we to summarize or write a brief something about the cases? Like what happened?
Yes.
Or it's not necessary?
You write, you write what happened. Hello?
Hello, sir.
You write what happened. In the case of Japan Motors and William, you write a brief fact. Send them out in a You write a brief fact. That's why I gave you the fact. Okay. So you see that all the cases that are given you, the facts are given. So you write a fact, brief fact about it, and what be about 4 lines be. Then you write the holding. The holding. So it was held that the holding. Then you say that it was held that, or the Supreme Court held that, or if there's a judge, you mention the judge's name, you say Amosechi J stated that. Is that okay?
Sir,
All right. So please, we are done with the hierarchy. This question is solved. You get your 40 marks. Papa, on our corner. What again? Huh? Okay. So on that note, we've come to the end of today's lecture. There are some people I wanted to check on some people, but you don't worry.
Sir, please send the IRAC AU for us.
I'll do so. Okay. So thank you very much. Have a good evening. Yeah, bye-bye. See you next week.
Yeah, thank
Those
you.
who,
Bye-bye.
those who are not
Thank
in
you, Doc.
Ghana, there are 3 people, there are 3 or 2 people who are not in Ghana who will not make it next week. You write an assignment. So contact me for your topics. You will have different topics also.
So we are 4.
I know. The faculty has given me only 2 people, 2
Sir,
or
please
3.
We
kindly
add
add
our names.
you.
Those of us who won't be around. You share the list with you.
But do you know how the assignment will be?
Sir, please kindly add Paulina.
Sir, they are
like the
about 5.
Ghana one. We
The
like
rest
the
of us,
Ghana one.
the rest of us, everybody is coming next week to write the test.
So we like the Ghana one.
Sir, Prince Aude Benjamin, I can't come because of my leg.
Talk to the faculty about it. Okay. Thank you. Bye.
Okay.